join back with, yeah, thank you. Okay, so going further, now I would like to run you through the topics we will be discussing today. And today's topic is a property law. Uh, Voice is not loud enough. Can you guys hear me now?
Yeah, loud and clear.
Perfect.
Yes,
So
loud.
today's topic is property law, and we will be talking about the ownership, occupancy, buying, selling, lease, and all related topics, and in general, if you are doing any research on it. Mr. Datta, could you please turn off your camera? No, you are muted. I can't hear you, but you are occupying the whole screen. Could you please turn off your camera? Thank you. Okay, so very soon we will be representing our clients in our courts, and it's very important that being a legal representative, you should have very clear and a concise understanding of these topics so that you can just represent your clients in a better or a more accurate way. So after this, we will be discussing the subtopics which we have underneath these topics. But again, property law is a very intensive and a vast subject, and NCA tried to summarize it in 11 main topics. But it doesn't mean those are the only topics. The basic important thing to concentrate here is the relation between these topics. You cannot pass property law exams by having understanding of these topics independently, because these topics are very much interconnected. They won't ask you questions from one topic or a two topic. They're going to give you one set of facts, which going to be the will, and they expect you to describe every transfer there, and which mostly collaborate the whole syllabus. So do not expect this thing that they're gonna ask you one topic, or they're gonna ask you contingent transfer. They will not, in their fact, they will not mention that. They want you to figure out what kind of transfer is this, what kind of interest this person is having now, and what is transferred actually. So from the facts in hand, you guys need to tell your examiner, okay, this is determinable interest, this is defeasible, this is contingent, and this is some conditional interest, this is tenancy, this is lease license. They want to give you, they're going to give you one story, and you have to figure out what is that. Then you need to tell your examiner what is transferring, what is transferred, what will be transferred in future, what is contingent on future events. So it's very important that you should understand these concepts and connectivity. If you cannot connect these topics, then there is a difference. These are not the independent topic. So you need to know how to connect these. And when we talk about exam, in property law exam, mainly you get 5 questions approximately. And the major part of your marks will be covered by will question. And will, always they ask will somewhere around to 30 to 40 marks. They always put 30 to 40 marks question for the will. And now that is a major portion of your exam. You will definitely get the question on ab original. You will definitely get a question on registration. You will definitely get the question on easements, and sometimes fixture. So these are the topics you should know, because you will be getting questions on these for sure. But the main thing, which is very, very important for your future also, is the understanding towards will. It's very important to understand how to execute will and how to write will. So they put 3 to 4 transfers in a will question, and they always want you to go step by step. What is the first transfer? It is a life tenant, or it is a conditional interest, rule of perpetuity, which is 100%. They're going to test you on rule of perpetuity, and they always put all these things in 30 to 40 marks. And even if you go with the very good understanding of rest of the 60% uh, exam, they always want you to do well at will. because it is very important part of the real estate. Wills and a power of attorneys are very important for a lawyer to understand and to execute. So this is how they want you to do. They want you to write a very accurate concepts during the will answer. So from the next class onwards, we'll start studying possession, and that is really important for you guys. So I request that you should put all the concentration while studying will. That is the reason I just mentioned that we will discuss will near the exam, and I just occupied one session for the practice because I know how important it is, right? You guys are good? Hello?
Yes, good so far.
Yes,
Ah,
yes.
okay.
Yes, we're good. Yeah.
Okay, perfect. So it's very important. I always mention if you want to understand your subject well, you need to understand your syllabus well. Syllabus is a kind of Bible. So just try to print out at your first availability, because if you know what are the topics and you can just count on your fingers, then that means you are good at this subject. So it is really important you know what comes after and what comes before. There is a reason behind it. There is a reason for putting those subjects in a sequence, right? Those topics in a sequence. Okay. I request one more time, please turn off your cameras and turn off your mics. Okay. I don't want others to mute you guys and lack concentration here. So please, you guys, mute yourself. Uh, Hello, who's that? Who's this person? I'm not sure. So you guys are disturbing others as well by not muting your mics. Please, I have a humble request. Please mute yourself. Okay. So now I'll come to the study material. NCA provided you a few of the books and a few of the articles to read. Book is really lengthy at this point of time to go through because exams are already around the corner. So what I'll recommend is I do have some notes, PowerPoint presentations, IDEX, and sorted answers, drafted answers for the NCA sample questions, and I do have 5 practice questions. So, which I feel is enough to pass this exam, and I will share for your considerations. I will share one by one the way we're gonna complete the topics. I'll start sharing these things accordingly. Okay, because there's no point of sharing in a one go, then you guys gonna be confused. So now what I'm gonna do is I'll start with the PPT. I'll share this PPT on your screen. Let me know if you guys can see it. Okay. Okay, so can you guys see this PPT?
No, your screen is not sharing yet.
Now?
No.
No, no, can't see it.
Okay, just give me 1 minute here. Can you see now?
Nope,
Nothing?
nothing.
Okay, let me try again. Just 1 minute here.
Yeah, we can see your screen.
Yeah, just 1 minute. Okay, so I think there is something I have to. Please have the printout for the PPT. Hello?
Yes, yes, I do.
Okay. I'm not sure if everybody have it because a lot joined in a 5-10 minutes, last 5-10 minutes. So I need to know if they have it or not.
I was wondering for the next class if you have any printouts or handouts, are you able to send
Mhm.
them like today or tomorrow before the next class, so we have enough time to print it and just go through it so we
Surely.
understand you better when you're just explaining?
Yeah, surely. Because as per my understanding, I think you guys already have it.
Yes, we have the printout. Yes, we have the PowerPoint, of course, yes.
Mm.
I'm just saying for the next class or whatever, if we're going to use this, that's fine. But if there's something else, that would be
Oh,
handy
next
to.
is going to be on Zoom because I'm really troubling with this Skype thing. And can you see now?
Yes.
Perfect. Is I'll be shifting to Zoom in the next class, and then what I'll do is I'll put everything on a Zoom, including recordings and everything, so that you can just have it from there. Is that okay?
Sure, that's fine.
Okay, perfect. So
Yep,
this the PPT somebody just shared it. This is not the updated version because I just updated PPT today evening. Can somebody share it the updated one? The one which I just shared it with others also, so that others can have to. Simran, can you do it? Okay, let me do it. Just 1 minute. Okay, so I'm sharing this PPT again for everyone who just joined in past 5 to 10 minutes so that they can pull up this and we can start now. Okay? Yeah, this one. Okay, so just 1 minute here. Okay, so you guys can pull up this PPT. And this is somebody's again and again sharing the same one. Okay, so let's start with this one only. What I'm gonna do is
the one that you shared today, that was dated March 18th, 2020. So is that not the latest one, or is there one later than that?
that is the latest one.
Okay, good. Okay.
Perfect. So let's start with this. Okay, so this is the PPT, and I'll pull up this one once again. Okay, so we'll start with what is property. Before I go and explain this, I want you guys to take a stab here. Anybody want to take a stab here? What you guys understand by the term property? Anybody here? Hello? Hello? Hello?
Hello.
Yeah.
Yes, yes.
Anybody want to take a stab here? You guys want to discuss what is property? Before I'll go and let everybody know what is property. Anybody else want to take a stab here?
Hello.
Hello?
Yeah, I think property is something that anything that can be legally owned.
That is right. For the layman's language, that is very much right. Anybody else?
It's something to do with like the property which is you legally own, and also other properties like chattels. Your car is also a property, and development rights could also be your legal property.
Yes, that is right. So basically, what NCA wants you to understand is there is two types of property, and one is a real property, and one is a personal property. Now, what is real property? Real property is something which concerns with the land, and the personal property is something which is movable property, which can move it. But there is a difference. the thing which is a real property today can be a personal property tomorrow, and the thing which is a personal property today and can be a real property tomorrow. How are we going to differentiate this? It is very very important that we should understand, because as in a conveyancer you guys will be selling property. So if you are selling a real property, you need to know what is a fixture and what is a personal property. Very importantly, you need to differentiate for your client that this is a fixture on his property and this is a personal property belongs to the other person. So now how we going to differentiate this? Anything which is already attached to the land and in a way that you cannot take out that property, that is a real property. Anything which is attached to the real property uh, in a way that you cannot take out that in a future or in a present time, that is a real property. Why? Because that becomes a fixture, and once it become a fixture, it converted into a real property. And what is a personal property? I'll quote an example here. What is a car?
Car is a personal property.
Okay. And what
But
is a house?
listen, if something is, as you say, it is attached to the land.
Mhm.
Suppose in my house there is a chandelier.
Can you introduce yourself? What is your name?
I am Surinder Datta.
Yes, Mr. Datta.
Yeah, it is a chandelier.
Mm-hmm.
It is. Don't you think it depends upon my intention that it is attached to the house, to the drawing room. But
Mm-hmm.
when I clean it, I tell my electrician to remove it once in 2 years and take to his shop and clean it.
Mm-hmm.
Then again he brings back and attaches the chandelier, which
Mm-hmm.
normally happens, to my
Mm-hmm.
drawing room. So
Mr.
as
Datta,
you say,
any practice anytime?
sometimes it becomes personal property,
Mhm.
sometimes it becomes part of the house.
Okay,
And
so have you
uh,
taken my
it,
classes anytime before?
it depends upon my intention. And as you say that it is a
Let's not
very
take this time. Let's benefit these 2 hours. So, Mr. Datta, let me explain this rather than you explaining for others. Okay, so I'll put in question again. There something which is attached to property can be which is attached to a land can be a real property, but again their legal titleship always changes with the time and the status, how it
hmm,
changes. So the chandelier which you are talking about, once you buy a chandelier, it is a personal property because it is a movable property. You can move that chandelier anywhere and it is a personal property. But once you attach that chandelier in a way that you cannot take out that chandelier, once you're going to take out, that will damage your roof, right? That will damage your roof. Then it becomes a real property. Why? How it becomes a real property? Because it becomes a fixture there. Now it's a fixture, and once it's a fixture, it becomes a part of the real property. So this is very important to understand what is the difference between manufacturer's house and a modular house. When we talk about manufacturer's house, if those houses has a wheel, we always call them personal property. They are not attached to a land. They are having wheels and they are moving, and they have a chassis number like a car. They have a vehicle identification number like a car. So those are like movable properties. Once it is a movable properties, those are not the real properties, those are personal properties. Once you will take out those tires, once you will tell the motor vehicle act that you are fixing this modular house or that house to your land, it becomes a real property. So your title or legal title always changes with the your intention, the way you said your intention, and the way you wanted to change that thing in a picture. Once a personal property, but now you want to change that property into a picture, and once it become a picture, it becomes a real property. So it completely depends. It's very important to figure out in your exam from the facts in hand what examiner is trying to ask. What examiners always want to listen from you guys, that this is a picture or this was a picture, this was a personal property, but this is a fixture now. So examiner want you to explain what is the travel time between personal property becoming a fixture and then becoming a real property. So you need to explain your examiner this was a personal property. How? Because it was a movable property at that time. Once it was a movable property, it was a personal property. But now, because it is fixed in a land in a way that we cannot take out and it cannot move anymore, it becomes a fixture. And once it becomes a fixture, it becomes a real property. So this is very important for you to understand and you to explain your examiner that you really understand this concept. Is that clear with everyone?
Yes.
Perfect. Going further, when we talk about, thank you. When we talk about personal property, we all there's always a very generous example of trees. Now we have plants and trees. So how we gonna differentiate what is a real property and what is a personal property there? Supposingly, I'll quote an example here. I think Rekha is there. So Rekha is having a farming business and she has a crop on her farm. Is that a personal property?
Yes,
How?
because it's movable. The crops can be
Crops
harvested
are,
and
how
moved.
come crops are
No,
movable?
They are stuck to the ground, right? They are in the
no,
soil.
Yeah.
they are
So
real
crops
property.
are
They're
not
not
movable.
personal
I-
property.
Yeah, because their legal status right now in today's time is a real property because today they cannot move. Once she'll have a crop, she can sell that crop and then it becomes a personal property and she can sell it anytime. But right now, it is not a real, it is not a personal property. Right now, it is a real property for her. So this is, please note, please pen down this thing. You will definitely gonna get question on fixtures and chattels, which we will be discussing further. It is one of the important topic, and if you will get a single question on that without the collaboration of any other facts, it will carry your 10 to 15 marks. So then you need to tell your examiner how you differentiated and how you reach to your conclusion, whether it is a chattel or whether it is a fixture. So if you guys are making a note, just make sure that you will put there in a note that it might be a standalone question for you guys for 10 to 15 marks somewhere. Otherwise, it always get collaborated with easements sometimes or adverse possession sometimes they ask these kind of questions collaborated with adverse possession, that somebody is having a hut on someone else's property. So whether hut is a chattel or a fixture, they want you to differentiate. So fixtures always you will get stand alone questions on a fixture. Clear? Is
Yes.
that clear? Okay.
Yes, it's clear. Are you going to go over that again, like at some point?
Yeah, sure, if you want to. Rather than discussing these concepts, I also want to let you guys know how important those are from the examination perspective, so that you guys should know how much time you should spend on these topics, right? You good? Hello?
Yeah.
So basically, property is divided in two parts. One is a real property, and other one is a personal property. But their legal titleship always changes with the time. Sometimes whatever is a real property today can be a personal property tomorrow, and whatever is a personal property today can be a real property. Hello, everyone is sleeping there.
Yeah, we're following.
Yeah, so property tomorrow. So you need to examiners are really sharp here, and they always put you in a situation that where you're gonna get confused or whether it is a real property or whether it is a personal property. Just remember one thing, which is movable, which can move, will be a personal property. If something doesn't move and attached to a real property on a way that you cannot take out that property from the land, that is the basic example of a personal property. to understand this is a manufactured versus modular houses. So when we talk about manufactured houses, we always claim that those are like personal properties. Why? Because those doesn't have any titleship. Though modular houses are always have a title in a building code and any kind of state or a province building codes. So we always claim that manufacturers are like a personal property. Manufactured houses have a identification number, like the vehicle have a VIN number, and they are registered under Motor Vehicle Act or something. So we always consider that manufactured houses are like personal property. You can move those houses from one place to another. Why? Because those have wheels. Once you'll take out those wheels and you fix that house in a land in a way that you cannot take out those houses, those become a real property. You guys are understanding that?
Yeah.
Yes.
So
Yes.
it can either be a personal property or it can either be a real property. Now you guys have to decide if what kind of conversion is there. If you are converting your personal property into your real property, then what you need to identify, what are the facts you need to identify? That they cannot be taken out from real property, and once you will try to take out those from the real property, the real property will be damaged. Okay, you guys are getting it?
Yes.
So,
Yes.
just pen down. There has to be 3 points when you are converting a real property. First one, it has to be attached to a permanent foundation. It is very important that it has to be attached to a permanent foundation. And secondly, anytime you are converting a personal property into a real property, which are like a manufacturing house, you always need to get a title and inform motor vehicle act, that motor vehicle department, that you are converting this property from a personal property to real property. This is not important from the examination point of view, but I want you guys to let you know. Okay, perfect. So can we move on to next topic?
Sure.
So you guys are good with what is a
Uh, will you do us a favor? If you
Mhm.
can, if you can send these uh, uh, notes, because now on our WhatsApp or email, something like that, so that we can print it out.
Is this Mr. Datta?
Yeah, yeah.
Mr. Datta, definitely I'll share everything. So if you have any doubt, rather than I mean, like we have very less time. We have only 2 hours, and I want to take advantage of these 2 hours. You can call me after the class. Okay.
Okay.
Perfect. Thank you. So moving forward to the next topic, which is boundaries. So anybody want to take a stab here? What are boundaries and what you guys understand by the term boundaries?
Boundary means set the parameters,
Mm-hmm.
decide the parameters, kind
Mm-hmm.
of. Yeah, that is boundary.
Anybody else?
Boundary, what I have studied from, you know, as a layman from a book is that uh, I think
Okay.
ab-
No problem.
ab-
No problem,
above
Mr.
the
Datta.
above the land and below the land, that is the boundary. That if I own a house,
Mm-hmm.
anything which is beneath my land is also belongs to me, and above the land also belongs to me, but subject to certain exceptions. It can't be unlimited. I
Okay.
don't,
Thank you so
Uh,
much.
if I will say
because
something,
because I won't be able to enjoy it. I can only enjoy a particular space above my house, and likewise, I can only enjoy a particular land, soil below my house.
Okay,
I,
perfect. So
I
I'll
can't,
take okay, I'll explain it to everyone.
I
So
can't go.
basically, in a layman's language, it is very much right. Boundaries are like parameters, parameters to decide ownership, and it is very very important topic. How? Because you will definitely get questions sometimes on a riparian rights and sometimes adverse possession. So these are the two topics they always NCA always test you on. Adverse possession. 85% they always test adverse possession. Riparian right, they always club with some other topic. They don't ask independent question on a riparian rights, but make sure that you won't take these two topics very lightly, because adverse possession is something which is very very important, and they always test you guys on adverse possession. Why? Because in some of the provinces there we have land which is not where nobody knows who occupy that land or who own that land. People, sometimes people think that this land belongs to crown, but nobody know about it, and they always, and later on times and after some time, they always find adverse possession on those properties. So they always want you to understand if there is adverse possession, how to deal with it. Okay, so make a note there. After a fixture or chattel, the important topic in your syllabus is adverse possession. To understand the adverse possession, it is very important to understand the boundaries first. If you don't know and if you are not clear how to differentiate boundaries, it will always be, there will be a confusion, always a confusion to establish adverse possession. Because if you will tell your examiner, okay, this is adverse possession, he don't care about it. He wants you to establish adverse possession. He won't go with your instinct that, yeah, I think it is a adverse possession of this. As per the facts in hand, I can say there is adverse possession. He won't be satisfied on this. He wants you to establish in your answer how it is adverse possession. So now we'll start with the boundaries, and just to establish that, I want you guys to understand these this topic very importantly. Now, in a layman language, again, yeah, it is parameters which decide ownership. But there, if you guys can see the screen, there is a latest version of Introductory Jaswal, which means that the owns adverse possession below into the indefinite extent, which is practical. So if you have a house, you can't say I have a right up to the
We're
heaven
having a
and
difficult
no
time hearing you.
airplane can cross.
Ma'am, you're breaking actually.
Yeah, we can't hear you at all.
Can you hear me now?
We can hear you,
Hello.
but you're totally breaking up.
Okay, can you hear? Can you guys hear me now?
Right now, yes, but yeah.
Is everybody getting this trouble, or some of you guys? Okay,
Yes,
let
yes,
me.
we're all.
Yes. Yeah.
No,
I'm so sorry.
I'm not getting in India. Its voice is very clear.
Okay, no problem. I'll explain again. So, ideally, people says that anything up to the heaven and below to the indefinite extent, I have an ownership, which is not a practical approach. And quote doesn't go with the maximum literally. They have a prudent person test. What is a prudent person? Okay, we have two people here, which I know very well. One is a Simran and one is a Rekha. So let's assume these both are like neighbors, and suddenly Simran planned to do construction in his house, and his one of the machine, construction machine, is hanging on Rekha's property, but hanging on a very much let's say on a three-story building height. So can Rekha claim intrusion, interference? Can Rekha claim that it is inside my boundary and it is an interference?
Yes, she can. She can say that it is protruding in her territory without her permission.
Okay, anybody else want to take a stab here?
I think this Ditto and Alberta power limited case is applicable in this case.
Okay, so let me explain. Okay, Rekha cannot claim that anything up to the heaven is her boundary. No, she cannot claim. Why? Because it become a common property. Common law principle says it becomes a common property. She can claim her right and her titleship and her entitlement up until the height. She can have all the rights to enjoy up until the height she can, but she cannot claim up to the heaven. There is a limit to it. So this is the reason court does not apply this maxim literally. Court always go with the prudent person test. What is a intrusion as per the prudent person test? So if I'm a prudent person or XYZ is a prudent person, I can see that that machine is hanging on 100, maybe 1000 feet, which is not an intrusion in any way for the Rekha. So it is not interfering and it is not an intrusion to her boundary. And remedy is always available, but remedy depends on the breach. So there is no breach. So you cannot claim this thing that up until the heaven, it's my entitlement or my right and my tittleship. So whenever they talk about boundaries, yes, the simple concept to understand that yes, you have a tittleship, that you have a right to the limit you can enjoy, and you can to the surface you can enjoy your right, not after that it becomes a common law property after that. So it only ownership only include rights above and below the surface to the limit that you can enjoy, and there is no interference and intrusion in your enjoyment. So in any case, Rekha cannot hang there on 1000 feet. So there is no intrusion for her. There is no breach of privacy. There is nothing such thing. So in that case, we always say it becomes a common property as per common law principle. You guys clear?
I'm sorry. There's something I noticed from the materials.
Mm-hmm.
The first material you sent, which is dated May 19th,
Mm-hmm.
what you're saying it's on that material. But the second one you sent,
Mm-hmm.
which is the updated one, which is dated March 18th, it
Okay.
says in the boundary page that the
Mm-hmm.
courts have applied the above maxim
Mm-hmm.
literally, which is
Yeah.
different from what it's on the page we are seeing on the screen.
Yeah, not literally. This is what I'm saying. That is not, the court is
No,
not
no,
applying.
get what I'm saying. You said the courts have resisted applying the above maxim literally. That's
No,
what we can see here.
not literally, but they applied quite a bit. They take it, but they are not applying literally. They cannot even apply literally. Nobody, if somebody will go to court and say that I have a right up until heaven, can court
Yeah,
apply that literally?
I understand what you're saying, but from the handouts, the material you gave us, it's
Mhm.
different. It's written differently from what you're saying.
Yes, I updated
So,
that material. I understand. I updated that material for you guys for the better understanding. So the code doesn't apply that literally, but for quite a bit. Okay,
okay.
clear? And there is a why so? Then code differentiated this in a two-way. Code divided one in a possessory right and is a usufructuary right. What are these two things? One, where you have a possession and you have possession, because you have possession, you have all the right over it, and where you have a right for the enjoyment and use only. Now, let's put it this way. So let's quote an example. We have Mr. Datta here. So let's see if Mr. Datta owns a house and Simran is a tenant there. Whose right is a possessory and whose right is a usufructuary right?
Ma'am, again you're breaking actually.
Could you please repeat the question again?
Yeah, you're
I'm
breaking
really
up.
not sure what's happening. So, yeah. So, code divided in between two things. One is a possessory right, one is a usufructuary right. So, let me quote an example. If Mr. Datta have a house and Simran is a tenant in that house, whose right is a possessory right and whose right is a usufructuary right?
Simran has a possessory right.
How come Simran has a possessory right? He's a
Simran
tenant
has a
there.
using right.
He's a
Yes, he
tenant.
Mr.
has the
Datta
right
have a possession
to.
right because he is the owner of the land.
Yes.
He's owner of the property.
So Mr. Datta has a possessory right because he has a titleship of that property. He has a possession of that property. But Simran has a right to use that property for a time being, right? So this is how we divide between a possessory right and a right to use. And now, if now what court did is, court is really smart on this. When it comes to Simran right, they always say because Simran is a tenant there, he also have a possession as in a tenant and a contract. But that is a different story. You guys don't need to go there because you are not having a trial in a court. The only thing you guys need to understand to clear this exam is there are two types of rights. One is a possessory right and one is a right to use, right? So the machine which is hanging in Rekha's house, that is Simran's right to use only that area, but not the possessory right, right? And if somebody has a way from others' property, that is a right to use, that is not a possessory right. If Simran, Mr. Datta, and Rekha, all three people have a house in a row, and Rekha doesn't have any way to approach main road but from way from the Mr. Datta and Simran's house. So now Simran take a easement from Mr. Datta and Simran's house every day, but she doesn't have a possessory right. She only have a right to use. She only have a right to use that land to approach main road. She cannot claim that because she is using this way every day she has a possessory right to use that way. No, possessory right belongs to Simran and Mr. Datta. She only have a right to use. This is very important to understand who's having a possessory right and who's having a right to understand when you are preparing for your easement question. Because when we allow or when we grant easement to somebody, we never get a possessory right, we only get a right to use. So if there are three houses in a row and the last house cannot approach to main road without a way from other houses via other houses, and other houses grant third house to reach to main road from I mean like via their property, that doesn't mean they are granting a possessory right. They are just granting a right to use. Are you guys getting it? How to
Yeah.
differentiate?
Miss-
So what you
Yes.
mean
yeah.
that a possessory right means right to own, and
Yes.
the second one is like only the right to use.
Yes, that is right. So when you are preparing your easement question or when you are preparing your entitlement, you need to know very well who has a possessory right here and who has a right to use here. Okay?
In nutshell, use possessory right normally belongs to the owner,
That is right.
and usufructuary right belongs to a tenant or person who is in possession of the property for a temporary use or of a certain period, fixed period, right?
Yeah, that is right.
So,
I'm
So now
sorry.
NCA
Sorry.
categorized bonds.
I'm very sorry. I don't want to take you back, but what's the how do you differentiate a possessory right and a ownership right? Because if you're saying that the possessory right also in parentheses is the right to use, and the
Mhm.
usufructuary right also in parentheses is a right to use, and
Yeah.
then how do you relate that with the
So,
ownership?
possessory right is always claimed as an ownership. This is one scenario which court always goes with. But if you are a tenant in somebody's house, do you have a possession of that property? Either if it is a temporary possession?
Yeah, but my understanding, I'm sorry, my understanding is, I think we're all lawyers here. My understanding is, as long as I pay rent for the
Mhm.
property, I have the right, I have the possessory right, but not the ownership right.
That is
I have
right.
the possessory right, then that possessory right gives me the right to use the property, but I do not own the property.
Yes, that
The
is right.
ownership right now dwells on the landowner who rented the property to me. I don't know if I'm saying if I'm going out of context, but that's my understanding. So if I'm going out of context, please put me right.
Not a problem. Just go ahead with your thought process and then I'll clear it.
Yeah. So what I was thinking is when we talk about possessory right and ownership right, I am
Yeah.
thinking that ownership right goes to the landowner. Then for the fact that the tenant pays rent, he has the possessory right at that point in time until the expiration of his tenancy. Then he no
Okay.
longer has possessory right.
Who's this?
Please, can
Silent.
I say something?
before you go ahead, and can I say something? Okay.
Okay, okay.
So, okay, because we do have a next chapter, which is a possession. I know you are confused bit on it. Once we'll have this chapter, your doubts will be clear because we still
Okay.
have not many slides to go through.
Okay.
Because we have only, this is kind of introductory class, and we have only 2 hours time, and I want to complete this. So next class is a possession, and definitely you will understand what is the minor differences between these two. There
Okay.
is a
Absolutely.
minor differences.
All right.
There is a temporary possession, permanent possession, ownership, but we can discuss in the next class because possession is a very lengthy topic. Okay, so
Thank you. Thank you so much.
Yeah,
Yeah.
yeah, because it is 9 points of ownership, as they.
And there is
sorry.
also syllabus changes in the possession.
Yes, that is right. Okay, so going further, NCA divided boundaries into basic categories. One is a vertical boundary and one is a horizontal boundaries. So what is this vertical boundaries, which goes like above the surface and below the surface, and what are these horizontal boundaries, which is land to land and land to water? Now when we talk about vertical boundaries, you guys are very much clear what is above the surface and below the surface. We have very limited or trivial case laws on a below the surface, mainly say if we talk about just a one, but above the surface we have not many case laws. If you go to Canley, you will find very little case laws, very few case laws you can go through it. There is no requirement because you are just writing an exam, and NCA hardly test above the surface and below the surface anytime. It's just for your understanding that you should understand this. Okay. I'm not sure what this connection problem is today. Okay, so hope you are breaking again.
It's
And
clearer now, though.
okay, and the other other category of the boundary is a land to land and land to water. Now, land to land is very easy to describe. There is very few disputes when we talk about, when it comes to dispute, it is very different dispute. Why? Because we always talk about property and these kind of, hello, hello. Okay, let me continue. So when it comes land, bounded by land, there are two steps you guys need to follow. The first general rule is, if boundaries are in doubt, reference will be given to the different kind of things. Like if you made a mistake in calculating your boundary, then there will be a different references to it. Like you always see what is the intention of both the parties. If there is any natural boundaries, like if there were any tree, if there were any wall or any kind of natural, if you find any kind of natural boundary, it is always easy to describe ownership. And if not, then a lines actually comes, we always say, okay, this line was coming from the corner, and this way we identify the boundary. But if everything fails, then a conventional line doctrine come into existence, which is a step two. So step two is a conventional line doctrine. Now, me and Rekha has a dispute. We are neighbors, and me and Rekha has a dispute regarding our backyard boundaries. And Rekha is not settling anywhere, and I'm not settling anywhere. I always think Rekha is claiming more land, and Rekha thinks I'm claiming more land. And there is no natural boundary. There is no tree to identify whose land is this, and evidences are very vague. So now we both come to the mutual discussion, and we're gonna mutually, under the conventional line doctrine, we're gonna decide, okay, Rekha, this is the line, this is the boundary line. After this, you have your own property, and this side it's all my property. So this is when, without any evidence, both parties come to a mutual understanding and create a boundaries. We always call it conventional line doctrine. Sometimes NCA want you guys to put this conventional line doctrine in your answer. So just remember, if you find in a fact little bit dispute regarding boundaries, always try to mention that there is always a solution of conventional line line down. Okay? Good so far? Hello?
Yes, yes, yes.
Yes,
Yes.
yes, yes.
Yes.
Okay. And the second one is land to water. This may be an examination question for you guys. Why? Because this activates riparian rights, and because Canada is having a lot of water boundaries, and there are a lot many riparian bodies. They always want you guys to aware of these rights. And what are these riparian rights? Now, sometimes they ask standalone question, a single question of somewhere around 10 to 15 mark. Sometimes they always club this topic with easement, sorry, with adverse possession. So you guys need to understand what is land to water and how it activates riparian rights. Now, when we talk about riparian rights, bodies, tidal water body, and one is the navigable waters. Very confusing. It takes a lot of time for students to understand what is tidal, what is a navigable, what belongs to crown, what belongs to the property owner. So if you read book, you will be lost for months, for weeks, but you won't be clear on that. It is very important to understand what is a tidal and what is a navigable. Now, how are you going to differentiate? It comes with the time, it comes with the practice, but it's very important that you guys should understand. So there is a difference between a navigable and a tidal. Now, what presumption says? Presumption arises that the boundary of land beside a non-tidal river extend to the middle of the river unless title stay otherwise. So just remember three things. If you guys want to pen down, please pen down. Tidal body water and a tidal river. These are two different things. So tidal body water and a tidal river. These are two different things. Tidal body of water owns up to the ordinary means high water mark. If it is until a high water mark, it's yours. What is after that? It belongs to crown. You have no right over that water. And the second thing is, okay, and the second thing is tidal reserved are treated as tidal rivers are treated as navigable, of course, because until the high water mark they give a right to the property owner. After that it becomes a river and they give a right to the crown, and crown owns all navigable water. So when it comes to navigable water, crown has all the rights, but when it becomes to tidal body and a tidal river, up to the high mark, landowner has a right, and after that, crown has a right, which are tidal rivers. The ownership is automatically goes to crown. You guys understood? I know it takes time to understand this thing, but I already mentioned this in my PPT so that you can read it yourself and try to soak in. And what are these riparian rights? Now, we always say if I have a
Sorry
property.
to interrupt you, Jagriti, but can you just explain the tidal body water and tidal river again, please?
Sure. Who's this?
Thank you. Gitika?
Hi, Deepika. Sure. So, tidal body and a tidal river, they always differentiate this a bit. So, if it is a tidal river, they always give you right as in a landowner. They always give you right until the high mark. You understand what is a high mark? There's always a high mark in a river. So if you are a aboriginal or if you are a person who is living with adjoining to water body, you have a fishing right. You have a right to use that water for your household things, but not for the commercial or agriculture thing. And you can take measures for the flood. These are the rights you have as in a riparian body. Hello, yeah, Deepika, you got it or not?
Yes,
Hello.
thank you, thank you.
Okay. So up to the certain mark, you being the landowner and being a landowner who has an adjoining land with a water body, you have certain rights, but your right is up until high mark. It's not like that if you are having a house adjoining to river, then you can claim, okay, because I'm having a riparian right, the whole river is mine, I can have a boat. You cannot have a boat, you cannot go to the middle of the sea, and fishing is not allowed there. You can do fishing until certain limit, until the high water mark. You cannot have your boat and you can go every day there for a boating and all that. There is a certain limit you can go until the high water mark.
And
Clear?
who decides the limit?
Oh, it is high until high water mark. They already decided it.
Okay, thank
Okay?
you.
It is until high water mark. Nobody have to decide it. They already decided it. They already marked it. So what they normally ask you, sometimes they put in question like that. There is a person who's an aboriginal, and because we all know they have a different rights. So they have this fishing right, and he was doing fishing over there. There is a case law on the same scenario as well. Sometimes they ask same kind of questions, and he is a riparian. So is it legally allowed for him to do fishing after high water mark? No, it is not. So he can do it until high water mark, not after that. And what are the other rights which riparians can claim? They can always use that water for the household purpose, but they cannot use for the agriculture purpose or any commercial purpose. Clear?
Yes, thank you.
Yes.
And let me ask this: if I have a house which is adjoining to river, and I'm having a flood, so what right I can? I mean, like what I can do there? Because for the agriculture purpose, for the commercial purpose, I cannot divert the water, right? They said you can only use it for the household purpose, and if I think, oh, I have a farm there and I can divert this water to my farms and it will be easier and
I think for emergency purpose, you can do that, flooding.
go ahead. Yes. Yeah, for the flooding, I can divert that water. I can take measures and I can always divert that water to a different route. I cannot do it for the commercial or agriculture purpose. Okay? Clear? Clear with everyone?
Yes.
Perfect. There are a lot many students in class I can see, but there are only 2 and 3 are responding. Is everyone getting it or not?
Yes, we are.
Yes, it is.
Okay. Who's that? Okay, so the next important topic is mines and mineral. During my time with NCA, I haven't seen any question NCA asked regarding mines and mineral. I'm not sure what they're going to do in April, but during my time, I haven't seen it. When it comes to mines and minerals, all mines and gold and silver mines belongs to Crown. Uh, you can get a
Let,
grant.
let me, sorry to interrupt you. In the riparian right, I can add few extra points for the understanding if you
Go
want.
for it. Go for it.
Okay, so what happened now, like all these right to use for the reasonable use is allowed, but now this right has been legislated, like what you
Yeah.
can do and what you can't do. So
Yes.
in section 21 of the Water Act, they definitely defined there that human consumption, sanitization, fire prevention, watering animal, lawn, all these household purpose, you don't need any permit to use that water. You can do that. But for extraordinary use like irrigation, manufacturing, then you need special permission. So this is also
Okay.
a part of riparian rights now.
Yeah. This is good to know for others that I'm like normally NCA don't ask in that much depth, but it's always good to know, right? So can we move on?
Yes.
Thank you. Okay, so mines and minerals, surface ownership of land may or may not include rights of mine. So if you have a mine underneath your house, do you think you own that?
No.
If you have a coal mine, then
You still do.
Yes.
Yeah, coal mine is permissible. There is not a need for any grant.
If you
If
have a gold mine,
then
No, that
that is
belongs to
vested to
Crown.
the crown. That belongs to the crown, I think.
yeah. So any gold or silver mines crown, that is important to know. I think you guys already know that in Canada, any gold or silver mine directly belongs to crown. You guys have no right over it. But if you guys have a coal mine and underneath your house, do you have a right? Because you are the ownership, you have ownership of the surface. Do you guys think you have a right of that mine as well? Anybody want to take stab here?
I mean, as per my understanding, that all mines and minerals are owned by the crown or the government, and I don't know if it's different in Canada.
No, it's the same in Canada as well. So it's always like we follow the bright line rule. And if you find any mine, even though if you find any mines, either if it's a coal, gold, silver, it belongs to crown. Okay. And in general reference to mines and mineral in a grant, adopt the language of the mining works, the commercial work, and a landowner at the time the grant was made. So there are two acts which you need to understand when we are studying mines and mineral. One is a Surface Right Act, Section 12, and one is a Surface Right Act, Section 12.2. Now, what these two sections says? First, two ways to access. Now you have a surface right, but can you enter mines? So consent of owner or occupier. And who's the owner and occupier here? Who owns mines? Hello.
Crown.
Yeah. So you need a consent or you need a grant of owner or an occupier, and Mr. Umar, it's different here. Okay, appear before the Surface Right Board to obtain a right of entry order. So Crown doesn't mean you'll go to Crown and get a grant. So where you have to go? You have to go Surface Rights Board, and you need to get an entry order, then only you can enter mines. Even if you have a house and there is a mine underneath your house, you cannot enter that mine. You have to apply for your right under Surface Right Act Section 12, and if that right will be granted, then only you will enter the mine. Okay, clear?
Yes.
Perfect. Now, this is not important from examination point of view, but again, because you guys have this subject in your NCA journey, then you should know about it. Surface Rights Section 12.2, there must be a separate consideration, sum of money to grant access. So sometimes you just need an access, sometimes you want to be you want to dig that mine, or you want to benefit, or you want to do some business from mining. You have a mining business or something like that, then there has to be a different grant. If any amount of money or any amount of sum is involved, then you need to have a different grant. Okay, clear?
Yes.
Yes.
Perfect. So we can move further.
Yes, please.
Anybody have any doubts so far, whatever we studied so far, starting from the categories of property, whether it is a personal property or a real property, how it should be differentiated, how they can be converted, how their legal entitlement converted with time and with basic criteria is converted. Anybody have any doubts?
I have a doubt about tidal and navigable, if you can.
Yes, yes, definitely we can do that. What is your doubt?
Yeah, in fact, we are not clear about. Uh, Suppose I have a house on the banks of Seine River. Then
Okay.
how much right I have to that tidal or non-tidal or
Okay,
this can you explain?
okay,
Yeah.
I'll explain again. So if you have a adjoining house, if you have a house adjoining to river, okay, what is your name, sir? Hello, what is your name, sir? The-
You're asking to me or you are asking to?
Whoever put this question, who wasn't clear, I'm asking the name of the person who did not get this title and navigable.
I think both of us, Mr. Surendra Datta and me. My name is Gurpreet.
Gurpreet, okay. So Gurpreet, if you have a house adjoining to a river, okay, you understood this much? Now, once you'll have a right adjoining to river, forget about navigable. Everything in a navigable belongs to crown. Got it? Why? Because then common law principle get activated and crown make it for the public use, not for the personal use. So you cannot have a right, you cannot have in rights in a navigable rivers because it becomes a public property and crown has an ownership of the navigable waters. Clear? It cannot be for the personal property. Is that clear?
Yes.
Regarding navigable. Okay, now we'll move to tidal. So, Gurpreet, when we talk about tidal, there are two types of bodies. One is a tidal body and one is a tidal river. So, when we talk about a tidal river, every river has a high mark. So, if water goes higher than that, then that means there is a flood alarm or there is an alarm. So, that high mark, you understand what is the high mark?
Yes, it means when the flood or something
I'm like we
emergency kind of.
yeah they just created a boundary which we said high mark. They calculate certain things on a high mark. Sometimes mineral beds are underneath high line. Sometimes they measure floods from the high line. So high line is used for different kinds of measurements. But being a riparian right, they even to calculate or even to access riparian right, they used high mark. So if you have in a house adjoining to river, which is a tidal river, you have a right up until that high mark. So let's say from is a high mark. So then you have a right until that 3 kilometers. You can fish there, you can vote there, you can use that water for the domestic use, or you can take precautions for the flood. But after that 3 kilometers, your rights get exhausted. Then it becomes a crown's ownership, not your ownership. So let me put it this way. So if you have a house adjoining to river, and until that 3 kilometers, we have a high mark. Now, with with the passage of time, gradually water went back, right? And
Yeah, right of a creation something.
yes, now you can see instead of water, now you can see land there. And you decided to create a hut there, and you created a hut, you created a garden. So that is, if that is under the 3 kilometers or high mark, that is your property and you have that land under the right of accretion because slowly or gradually accretion happened, water went back, and now you have that land to use. But if water went back 7 kilometers,
Oh, Robertson versus Wallace. Okay, I know
yes,
now.
even then you cannot use that property. You can use until 3 kilometer only where the high water mark was.
Okay, yeah.
You got it
Thank you
now?
so much.
Not a problem. Mr.
Yeah.
Datta, you clear now? Okay. So I'm not sure if Mr. Datta can hear me, but we'll move forward.
So
So
when we are talking about this, we have to talk about right to accretion. If there would be any kind of changing in the boundaries
yes,
related to the water, then we have to talk about the gradual transformation within the 10 or
yes,
20 years. Then we can say that if there is unnatural thing, suppose they are going to make any dam or anything,
no.
then will not be
Then you
considerable.
can. The basic principle it has to be gradual.
Gradual transformation. Okay,
If you
thank you.
make a wall or if you make a dam and then you create a land, it is not your land. Water has to went back naturally. So it has to be gradual and a slow process. It
Okay.
cannot be within 6 months, 2 months, 4 months. It's not then legal entitlement. So the
Okay.
basic principle which we follow is for the accretion is that water should went back slowly and gradually with the passage of time. Then you have entitlement. You got
Okay.
it?
Yeah.
Yeah,
Thank you.
Perfect.
yeah.
And
Jagriti, Jagriti,
yeah,
my name is Juliana. I just have one question, please, just
go
to
for
make
it.
sure that I understood correctly. And again, correct me if I'm wrong. The possessory right is with the owner of the person who has the possession. Can be adverse possession, constructive, and so on. Using the title, it's only the owner of the land, right? It's not the possessor.
Sorry, I'm really not getting your question. Could you please repeat that once again?
So I'm trying to understand the difference between possessory right and using the title.
Oh, sure,
So
sure.
possessory right, it's the possessory right has the owner of the person who has the possession.
That is right.
And that's right, right? And using the title has only the owner, right?
No, there is a difference. Let me explain once again. I'm sorry, I missed your name.
Juliana.
So, yeah, I'm not sure if I'll be pronouncing right. Juliana? Okay. So, possessory right, let me explain this once again. So, if you have a legal entitlement is one thing, and if you have a possession is a one thing. Sometimes these two things can be different. Once you read possession chapter, you will understand then the one who has a legal entitlement, he may not have a possession of that property. So supposingly you have a property, and but you just left Canada for 6 7 years. That means you have a legal entitlement of that property, but you don't have a possession of that property, right? Understand? But sometimes maybe you don't have a legal entitlement of this property, but you are living at that property from past 10 years. Then that means you have a possession of the property, but you don't have a legal entitle of property, which we call it adverse possession. So these are like little tricky topics. Once we'll study possession chapter, which is the next class, it will make it more clear. It will be more clear for you guys, and little better to understand. So I don't want you guys to load with lot of knowledge today, then you will be confused. But yes, in a simple language, one who has a legal entitlement always, not always, but many times have a possessory right. But sometimes the person which has only right to use that property, he don't possess that property, he only use that property. That is a use structure right. You got it? Hello?
Yes, yes, thank you.
Yeah, it
The
is
name is
little
clear. Yeah, yeah.
once
Usufructuary.
we'll have a
Yeah.
once we'll have a class on a possession, then you will understand this in a better
Yeah,
way.
So for example, a tenant lease.
Yes, tenant
yeah,
and lease. Maybe you have a factory, you lease the property, and you have a farm on that property. You just lease that farm. So sometimes we only use that property. We don't own that property. That means that is only for the use, not a possessory right. Okay, got it?
yes. Yeah, yeah, yeah.
Perfect. So we can
Thank
move forward with the fixture. So fixture is very important topic. For sure, 100% it will be tested. Maybe a standalone question. You will be lucky if it will be a standalone question, but sometimes it is always clubbed with a will question. You got it? Hello.
Yes, 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 we got it. Thanks.
Perfect.
Yes, yes. We got it normally.
So just pen
Normally
down in your
club.
book or notes that you will
Normally clubbed with the wills.
definitely get a question on fixture, and it's very important for you guys to understand the concept. Now what anybody of you want to take a stab here and describe what you guys understand with the fixture, and how you differentiate fixture from the chattel, other than the student who already were there in a previous class. Anybody?
I mean, chattel is something like it's not affixed to the ground or the foundation, that is movable.
Mm-hmm.
And a fixture is something which is attached, like as Mr. Datta mentioned, like a chandelier or something that could be termed as a fixture, according to my knowledge.
Okay. Anybody else?
A chattel loses their status as a personal property, becomes a real property, is a fixture.
Okay, so your voice is not audible. We can't hear anything. It's
A,
blurry.
a chattel lost their status of a personal property, become a real property, is a fixture.
Okay, so I'll try and explain. So fixture, as I said, 100% is examination question. When you are taking a question on a fixture, it is very important that you should concentrate on four alphabets. What are those four alphabets? One is a I, which means intention. Then it comes R, which means relation. Then it comes M, which means method, and then A, which comes adaptation. So IRMA. This is the rule, because as I said previously, examiner will not be satisfied if you just tell him in a one sentence that it is a fixture or it is a chattel. He wants you guys to establish how it is a fixture and how it is chattel. So then you need to put this rule IRMA. Okay. So what these alphabets explains for us. So first is the intention. Sure. So when you are identifying fixtures from the facts in hand, you have to establish fixture or chattel with the principle of IRMA. What is this IRMA? So I already explained. I goes for an intention, R goes for a relation, M goes for a method, and A goes for an adaptation. So IRMA. Now you need to apply Last Sale Recreation Limited versus Canadian Camdex Investment Limited test, which is very important. Whenever you get a question on a fixture, just start with the test. That test Last Sale Recreation Limited test applies. And what does test say? How does test differentiate whether it is a fixture or it is a chattel? So we got four things IRMA from this test. First of all, we need to see the intention of the annexer, the person who's annexing this property in a real property in a way that it should become a fixture. What is his intention? He's just doing it for the use, or he's doing it on a permanent basis. If he is doing on a permanent basis, then it becomes a fixture for sure. Then there is no doubt about it. If I'm having a supposingly I'm having an aquarium of a wall size, and I decided to put that aquarium in the middle of my drawing room and a dining room so that it can divide both the areas. And I know once I'll do that, it won't be easy for me to take out that, because it is a wall size aquarium, which is a very big. So I cannot move that again in my life. Then I'm doing it with intention that this aquarium should become a fixture. Okay, clear? Intention I is clear for everyone.
Yes, it is.
Yeah. So next is the relationship of the annexer. What is my relationship with that property? I own that property or I don't own that property. So I own that aquarium. That is my aquarium. I am the owner of that aquarium. So I am the owner and I am doing with my intention to fix that in a wall. So I want that particular property to become a fixture. Clear?
Yes.
Any doubt regarding our relationship? Any doubts? Anyone? People are sleeping behind the cameras. Hello?
No, it's clear. It's clear.
Okay.
We're good. We're good.
It's clear.
Okay. So let me put this way. Um, it's not mine, but I borrowed aquarium from the Simran. I said, okay, he's going to India for 1 year, and I told him like, okay, I'll feed these fishes. I can take care of your aquarium for this 1 year or 6 months time, and then I fixed this aquarium in my wall. Is that legitimate? Do I own that aquarium?
No.
So you need to establish relationship in your exam. You got it?
Yes.
Perfect. And then comes the method of the annexation, and then comes the adaptation of the real estate. So you guys need to put all these four points in a sequence. Now, what you understand by the method of annexation? Again, the method means I want to fix it in a way that it cannot take out. I don't want to put it in a temporary way. I want to put it in a permanent way. My method to put that aquarium there is a permanent, not the temporary. I want to put this aquarium in a permanent method. I don't want this to move again in my life. So I want to convert this personal property of mine into a real property by fixing this in a real property in a way that we cannot take out this property in future. You got it?
Yes.
Clear?
Yes.
Perfect. Then adaptation to the real estate, which is the fourth point, which is very easy. Again, the same principle lies
Not
here.
clear.
I really simplified. I just make a note underneath and I made how to simplify it is. Just understand one thing from if you have a facts which says that you have to differentiate between fixture and a chattel. I really put a simplified and underneath these four topics. If you guys are looking at the same PowerPoint presentation, you can see I mentioned, is it permanently attached? Was it attached by the owner of the real estate? So if there is a yes for these two questions, then it is a fixture. And if a no, if there is a no of any of these two questions, then it's a chattel. So it's very easy to simplify this. Okay, got it? Clear for everyone?
Yes.
Hi, Jagriti.
Sorry.
So even if one of them is not is not fulfilled, it would be chatting.
Sorry, I didn't get that. I'm sorry. Could
Uh,
you?
no, I'm asking like even if one of these IRMA is not fulfilled, it would be a chattel, like not a.
And it becomes a chattel. This is why I mentioned underneath these 4 points, if you are looking at the right PPT, underneath these 4 points I just mentioned a simplified, and I mentioned two question in front of that simplified topic. Is it permanently attached? First question mark. Then was it attached by the owner? Second question mark. If your answer is yes for these two questions, then don't think the next thing. Say it's a picture. But if your answer is no for either one of this question, then say no, it's a chattel. Be clear in your mind. Don't get confused anywhere. Just make it questions. If you get a no for any of either of this question, then it's a clear.
Okay.
Perfect. So the
Ma'am,
way
ma'am, sorry. Ma'am, can you explain adaptation again? Adaptation again? I'm sorry.
adaptation to the real
Just
estate, adapted by the real estate, again the same principle lies that it is adapted in your real estate property. That when we okay, let me explain. Who's this? Sorry, what's the name?
Ma'am Simran here. Simran here.
Simran.
Sorry.
So yeah, hi Simran. So let me ask you this: if you buying a property, if you buy the same house, my house which has a aquarium, and you can see that aquarium is attached in a way which cannot take out. So what you gonna think? It's a personal property or it's a fixture?
To me, it's a fixture.
So it is adaptation. That means it becomes a part of the real estate property now, and it cannot be take out. It cannot be once anybody else gonna buy this property, they cannot say that it is a personal property and you can take out. It is adapted in a real estate. estate property. You got it?
All right, thank you.
Perfect. So I do have this question. If somebody has a house, if Simran has a house and Simran has a chandelier, tell me this thing. If I'm buying that house and I don't want that chandelier there, so what I need to do?
You need to remove it.
Where are I going to mention that?
In your agreement of purchase and sale, you're going to
Yes,
mention it. Yeah.
exactly. So you need to see what is included. Fixtures are included in transaction automatically. Because that is a fixture, that chandelier is a fixture, that will be there in a property automatically. And if I want to remove that at the time of the purchase, I have to specifically mention that I don't want that chandelier on that property at my purchase. So I have to tell that in a contract that okay, I am buying this house because it is a fixture, it will be automatically there in a transaction. There is no question about it. And if it is a personal property, it will be excluded automatically. If I'm planning to buy a Simran's house and I just visited house and I saw very beautiful couch, that doesn't mean it becomes a property automatically, because that is a personal property that will be automatically excluded from the transaction. So if I want to have that couch, then I need to specifically mention in a contract, that in our sale and purchase contract, very clearly, that I want to buy this property with this couch. So remember, what is a fixture, which is that is automatically included, and what is a chattel or a personal property that is automatically excluded. And if you want to involve or include or exclude that, you have to specifically mention in a contract. Clear?
Yeah, just please explain method, because I third point, intention is clear, relation is clear.
Okay, Simran, you
Method.
want to explain for Mr. Datta?
Yeah, I'll do that. Mr. Datta, method actually means the way you have attached that shuttle to the fixture, basically, to the building, basically. Uh, can it be easily be removed, or it can? If it can be easily removed, it's a shuttle. If it cannot be removed easily, it's a fixture, to my understanding.
If suppose it is leaving any adverse impact on the property or any damage to the property,
Then it's a fixture. If
yeah,
it is
then it is
causing any
fixture.
damage, it's a fixture.
Yeah, if it is not causing any damage or adverse suggestion,
It's a
then it
chattel.
will
You
be
can easily
chattel.
remove it. Yeah, correct, sir, correct.
Yeah.
But if two earlier two concepts are clear, then it is a fixture and it becomes part of the real estate. Am I correct? Intention and relation.
You need to establish all four: IRMA,
Yes.
intention, relation, method, and adaptation.
Yes.
And I simplified for you guys, the one who don't want to go through all four factors. Or if you see that your wills question is only for 30 marks, and then there is a fixture thing, and you don't want to invest a lot of time in explaining fixture or chattel, then just look for the answer of two questions and tell your examiner in a simplified way that it is attached by the owner and it is attached permanently, so it is a fixture.
Okay.
You got it? Perfect.
So intention, in nutshell, intention is very important. Intention of the chattel, if intention of the owner is to use it permanently, then it is part of the property. And if intention is to remove it and not to use it permanently, then it is a chattel.
Perfect.
Hello.
Yeah, yeah. I'm listening. So I hope these concepts are clear. And if you guys have any doubt regarding these concepts, this is just an introductory class, and you hardly get a 10 to 15% question from this class. The major part is the possession and contingent transfers, registration, easement, accretion, and adverse possession. These are important topics you need to go through. Lease and licenses, wills. So these are very important topics, and the one who's going to sign up for this class, I won't recommend you guys to miss I'm like live class and go for the recording, because the more you get involved in during your live class, you don't get involved during the recordings. And I also understand if you guys are getting it or not, what is your capacity to understand, or I can repeat it 10 times for you. So I always recommend to have a live class rather than recordings. Okay. Hello.
Yes, yes.
Yes.
Okay. So any questions before we end up this class? Anyone have any
So
questions?
would it be possible for us to get the materials ahead
Yeah.
of time before the day of the lecture?
Silas, I think you must be having all the material beforehand, right?
Are we still using that same materials?
Yeah, that is the same material.
Because I know from the one you just sent now, it's a little bit
Mm-hmm.
more packed than the other
Mm-hmm.
one. It's more detailed than the
Okay.
previous one.
Not a problem. I'll post that before the
Yeah.
class.
And Jagriti, once you finish the class, can I talk to you?
Sure. But
Uh,
not today. I'll be leaving, and we can talk tomorrow.
but
So is this
I would be grateful if you can send your contact number
Sure.
so that we can call you for WhatsApp call and timings, because I have to call from India.
Okay. Not a
Yeah,
problem.
definitely.